The United States Supreme Court receives thousands of petitions every year from prisoners asking for their cases to be reviewed. The overwhelming majority of these requests are quickly read, categorized, and dismissed. But in the summer of 1962, a 50-year-old drifter sitting in a Florida state prison cell picked up a pencil and wrote a letter that forced the highest court to stop and pay attention. This is the actual petition he mailed, written on lined prison stationery by a man who never finished school or studied law. Through crude handwriting, he argued that being forced to represent himself in court violated his rights under the United States Constitution. The Supreme Court didn't discard the letter. Instead, they agreed to hear his case and revisit a major legal precedent that had stood for 20 years. Before 1963, American courts operated on a two-tiered justice system. If you were charged with a crime in federal court, the government guaranteed you a defense lawyer. But in state courts, where the vast majority of criminal prosecutions actually happen, defendants had no such guarantee. This gap existed because of an old legal precedent known as Betts v. Brady. That ruling stated that states only had to provide a lawyer if the defendant faced the death penalty, or if they could prove special circumstances, like extreme mental incapacity or a highly complex charge. For a standard felony, you were on your own. This photograph shows Clarence Earl Gideon. He was penniless, had spent years drifting across the South, and had been incarcerated several times before. In 1961, Florida police arrested him for a minor property crime, breaking into a pool hall and stealing change from a cigarette machine. Inside state courtrooms like this one, Gideon asked the trial judge to appoint him a lawyer. Because breaking and entering was not a capital offense, and because Gideon had no special circumstances to claim, the judge denied his request. Gideon was forced to represent himself. He did his best. He made an opening statement and cross-examined witnesses against him. But navigating complex procedural rules without training is virtually impossible. The jury swiftly convicted him, and the judge sentenced him to 5 years in prison. Gideon didn't lose because of bad luck. He lost because the state machinery functioned exactly as it was originally designed, pitting an uneducated citizen against a prosecutor who had trained for years in the mechanics of criminal law. Looking at the imposing exterior of the Supreme Court, it is worth asking why the justices chose to pluck Gideon's specific, unremarkable letter out of the thousands sitting in their mailroom. The answer is that several justices secretly hated the Betts v. Brady precedent. They saw this special circumstances rule producing wildly inconsistent and unjust outcomes across the country. They were waiting for an opportunity to tear it down. Gideon's absolute ordinariness made him the perfect test case. Because he had zero special circumstances to rely on, his case isolated the core issue. It allowed the court to examine whether poverty alone was enough of a disadvantage to render a trial unfair. This is Abe Fortas. To ensure Gideon's claim was argued with maximum force, the Supreme Court appointed Fortas to represent the drifter free of charge. By deliberately pairing a semi-literate petty thief with a high-powered attorney, the court engineered a contrast that highlighted the exact power imbalance they intended to destroy. This diagram visualizes the core mechanical logic of the adversarial legal system, exactly as Fortas argued it to the court. The entire system is built on the premise that truth emerges from balanced combat between equals. When the state removes the trained defense from the equation, it breaks the machine. Pitting a state-funded prosecutor against an uneducated defendant ensures the system collapses under its own weight, turning a trial into an inevitable execution. The justices agreed. On March 18, 1963, the Supreme Court voted 9-0 to completely overturn their old precedent. They established a sweeping new legal mandate. Under the 6th and 14th Amendments, states are now required to provide lawyers to all felony defendants who cannot afford to hire their own. The highest court in the country officially recognized a simple mathematical truth. A fair trial is impossible if only one side knows the rules of the game. Following the decision, Clarence Earl Gideon was granted a retrial. This time, he walked into the courtroom armed with a state-appointed defense lawyer. The outcome provided a stark contrast. Facing the exact same evidence and the exact same charges, but protected by competent cross-examination, Gideon was acquitted. The impact of the decision was immediate. In Florida alone, several thousand prisoners who had been convicted without legal representation were suddenly entitled to petition for new trials or immediate release. Almost overnight, state governments faced a staggering infrastructure crisis. They were legally forced to build entirely new bureaucratic systems to hire thousands of lawyers and manage tens of thousands of cases. This map illustrates the explosive institutional response to that mandate. The modern public defender system, a vast network of legal offices designed to represent low-income defendants, was born directly from the panic of trying to comply with the court's order. An abstract constitutional theory, sketched out on prison stationery, instantly forced the physical construction of the largest legal defense network in American history. Today, the reality of the system Gideon accidentally created is complex and deeply flawed. Built in a hurry and never given sufficient resources, the modern public defender network is chronically underfunded. Lawyers across the country are systemically overloaded, drowning in caseloads that far exceed recommended limits. While the fundamental right to counsel is absolute on paper, resource constraints mean that in practice, meaningful legal representation is often honored more in form than in substance. But the right does exist, and it exists solely because a man who had been failed by every institution he ever encountered still believed enough in their core principles to pick up a pencil and demand they do better.